We are back. Sam Seder on the Majority Report. On the phone, it is a particularly unique pleasure for me to welcome to the program Joseph Singer. He is a professor of law at Harvard University and author of No Freedom Without Regulation, The Hidden Lesson of the Subprime Crisis. And Professor, welcome to the program.
Thanks for inviting me. Happy to be here.
And we mentioned this before we started this interview, but for the sake of full disclosure to our audience, I realized in the course of my research that you were my professor in the 1 year of law school I attended at BU in 91. And you were my critical legal studies professor. I loved your class then. I'm very excited to talk to you about this today.
Well, this is it's fun to have a reunion, and it's a nice connection. I appreciate it.
Well, that class, I think I told you before we got on, I realized that that was part of my justification. I'm technically, I think, still on sabbatical. It's been about 24 years, so I'm not sure if they would let me back. But one of the reasons why I left was because I appreciated your class so much, but they only gave me, I think, 3 or 4 credits for it, as opposed to or I should say 2 or 3 as opposed to the full 4. And I realized what I was enjoying was not necessarily valued at BU. But it's great to talk to you today, and I'm quite convinced that at least some of the principles that you taught us at that time have informed my conversations with libertarians, and certainly based upon your book, I think that very well may be the case. But let's start here at the beginning in your book when you talk about. You are an expert at property rights, which is the sort of the fundamental building block, at least to the extent that I could get libertarians on the same page as to what they think is essential. You talk about this concept of regulations, not just making markets possible, but you can't have freedom without regulation. And you talk about it in the context at first about the 17th century and the feudalism or the feudalistic, I guess, sort of, or shades of feudalism we had in this country. Talk about how that developed and how that informs your argument.
Well, it's interesting. A lot of people don't realize this, but there was a form of feudalism that existed both in the state of New York and in the state of New Jersey, where I come from. There were lords that were given not only title to land, but some power to regulate it, and the tenants on the land had to pay yearly rents, and they really couldn't transfer their property without the consent of the lord. In New Jersey in particular, when the British defeated the Dutch, they sent in a bunch of settlers, and those settlers got deeds from the governor of New York, and they moved into 2 areas in New Jersey. But after they moved in, the king gave New Jersey to 2 guys, these 2 lords that were supposed to be the rulers of New Jersey. And they sent the cousin of one of those guys in, and he was the new governor. And he comes there and he says, "I'm your new governor, and all of you have to start paying rent to your lords." And the people that were already there said, "Why the hell should we pay rent? We already have deeds to the land that was given to us by the governor of New York. Why should we pay rent to any lord?" And they said, "Well, because the king gave the property to these lords." So the settlers in New Jersey refused to pay those rents, and there was a low-level civil war for about 100 years. It was not solved until around the time of independence, and the lords lost. The settlers refused to pay those rents to the lords, and they set up their own governments. They set up town governments. They said, "We don't need lords to tell us what to do. We're going to run our own towns." And there was a fight against having a feudal system, and feudalism lost. In New York, for example, there's a statute in 1787 called the Statute of 10 Years that just outright abolishes feudalism. And it says we're only going to have certain kinds of property rights in the United States, and those are rights that give people control over their own property, and they don't have to give loyalties to some lord. They don't have to do what the lord says. They don't have to get the Lord's permission to use the land the way they want. We want to have independent people that have the power to do what they want. So if you're going to have the American system of property rights, you have to outlaw feudalism, and you have to regulate contracts and make sure that those contracts can't, if you enter into them, they won't be enforceable.
And I mean, and then of course we get that in the context of it's added. I mean, I guess, or it's developed into the Constitution, into Article 1, Section 9 of the Constitution. But the idea being that the dispossession. I mean, that property rights come from a form of regulation as opposed to just sort of existing in nature in some fashion.
Well, that's right. So, people sometimes have this sense from John Locke that there's an empty land and people go over to it and they start creating farms, and then all of a sudden there's a few bad people that steal your crops at the last minute. That's what Locke wrote about. That's not the way it happened at all. For one thing, in the United States, you got to remember the United States was inhabited. There were people here before the English came. The Indian nations were here before then. There had to be a dispossession of Indian nations to transfer property from them to England or France or the United States. So that's one thing that we sometimes forget. But the same thing, is true about the change from the feudal system. They had to take property rights away from the lords and give them to the people living on the land. And they had to abolish feudal agreements. It took a civil war for us to abolish slavery, for example. And in the middle of the 19th century, they abolished rules that said married women could not own property on their own. It used to be that married women could own property, but the husband managed it. And that was all, taken care of to some extent with statutes in the mid-19th century that said women get to control their own property. They don't need their husband's permission to buy and sell it. But what that meant was that destroyed property rights that husbands used to have over their wives' property. The form of property that we have today is one that we take for granted, but we kind of forget that it took abolishing previous forms of property in order to get to the system that we recognize.
And so, I mean, and let's back up a little bit here, because the idea of your book is to find some type of common framework between those on the, from the center to the left and from the center to the right, to push back against this notion, which was made popular in just the years before I took your class at BU, during the Reagan years, that that regulation was a problem, that government was an obstacle, that there was that freedom and government is sort of a zero-sum game. If you want more freedom, you need less government regulation. If you want more government, that necessarily means less freedom. I mean, you're trying to bridge that divide.
That's exactly right. There's a kind of strange residue that we all have now that I think comes from Ronald Reagan, where he said government is the problem. And I think that way of framing things has had a big effect both on Republicans and Democrats, conservatives, liberals, libertarians. Everyone kind of thinks about the free market as something that can somehow exist without regulation, and that any regulation comes in takes away our freedom. That's just not the way it works at all. You can't have a property system without defining what property rights are allowed to be owned. You can't have a property system without having recording statutes and registration of title so that people are clear about what they own. And you can't have a market system without having rules of the road. You need to have rules about when people have formed a contract, what are the terms of the contract, what are the remedies that you're going to have if there's a breach of contract, are you allowed to change your mind or not? If you think about it, if I hire a research assistant and they agree to work for me for the summer, and then just as the summer starts, they get a better offer, and they go, work for somebody in some other place. If I were to go to court and say, no, I want a court order for you to work for me this summer, the court would laugh at me. They'd laugh at me because of this little thing called the 13th Amendment, We don't force people to work for other people. Well, that's a decision you have to make about how to interpret and enforce contracts. Same thing with, if I buy a car and then the car is dangerous or it doesn't work, you have to figure out, well, when I bought the car, was I buying a working car or one that didn't have any warranties with it at all? You need law to determine what exactly the promise was. That's why we have consumer protection law, to make sure that consumers get what they thought they were getting out of the agreement rather than what the producer was trying to get away with. There just isn't such a thing as a market in the state of nature. There's regulation is just another word for law, and you don't have markets without legal rules that determine the shape of the market.
All right, now I want to double back to that notion of fraud, because I think that I think that in the course of the far too many conversations I may have had with libertarians, fraud seems to be a point that they don't have an issue with, depending on the type of libertarian they are, because it runs to sort of a theft of property if you and somehow don't deliver what you promise to deliver. But I want to get back a little bit to the this notion of property needing regulatory structure, and the I guess the subtitle of your book, The Hidden Lesson of the Subprime Crisis. I mean, walk us through this. I think this audience is pretty familiar with MERS, which was the sort of the corporate privatized version that was set up to record deeds outside of the sort of agreed upon process that we have on the county level, actually, in states. But walk us through that, and why the subprime crisis was such a good example for your thesis.
Well, there's several different issues to talk about there. One of them is the fact that they gave subprime mortgages, meaning that they gave mortgages to people that were unlikely to pay them back. And you have a housing bubble and it bursts, and then there's foreclosures, and instead of the normal number of foreclosures, there were millions and millions and millions of foreclosures. Once you get a disaster that's that extreme, the courts are starting to have many more issues that they have to deal with. And, lawyers that are representing people that are losing their homes to foreclosure are trying to protect people's legal rights. And so they start saying, look, if you're going to foreclose on someone, where's the proof that you actually have the right to foreclose on this particular house? If you're foreclosing on, thousands within a particular jurisdiction, you want to make sure you're not making a mistake, and because they did make a lot of mistakes in some of the foreclosure proceedings. The problem was that the banks had created this entity called MERS, the Mortgage Electronic Registration System, that privatized the transfers of mortgages. And it made it much less expensive for them to transfer those mortgages from bank to bank. And in some ways, you might think, well, that would be efficient, it saves costs. But it only would have been good if they actually had kept clear records of all of the transfers. But they decided not to keep clear records of all the transfers. And people at my school that are in the clinic and do legal services have shown me some of these records, and there were many, many, many mistakes made on those records. And so as soon as you get into court and they're trying to foreclose, the lawyers say, well, let's have the bank prove that they own this mortgage. And then it turns out they can't do it. They don't have a complete chain of title. And then you say, well, show me the note. The note is the underlying obligation. They lost the note. So there's no proof that they actually have the right to foreclose. And then if you're in court, the court is trying to figure out, what do we do here? We don't have the actual proof that they have the right to foreclose, but we do know that the homeowner wasn't paying the mortgage. Someone has the right to foreclose on them. Well, who is it? What are the courts supposed to do in that situation? It created an incredible mess. The other thing that I think is incredibly important here is that the entire system, I think, was based on a kind of fraud. So I think libertarians, they don't like fraud. They think it's a form of theft. But the entire subprime system was based on leading borrowers to think that these mortgages were good for them. They would say, look, it's a low interest rate, you can pay it back, and I know it goes up to a higher interest rate in a few years, but you'll just be able to refinance. There really won't be any kind of problem. So people thought that these were things they could afford. That's why they signed on the dotted line. But it turned out they were not things that they could afford, and as soon as the housing bubble burst, there was no ability to refinance, and everybody lost their homes, and they were worse off than they would have been if they had not had these agreements. So I think there was a lot of deception that was involved in selling the mortgages to borrowers. There was also a lot of deception in packaging the mortgages to securitize them. They'd put them all together and they'd sell them to investors like pension funds and cities and towns, and then they get the rating agencies to say that they were AAA. Well, those cities and towns and pension funds, they're not allowed to invest in investments that are not safe. But if you call them AAA, people think they're as safe as Treasury bonds. And I think there was a lot of, they led them to believe that they were really safe, but they were not safe at all. So I think there was fraud underlying the entire system. And then you get that much fraud involved, and you get all these people that can't make their payments, and the property arrangements they created just wrecked the world economy. So you're sort of saying, well, what you and I can make a contract, what does that concern other people? Subprime crisis is, evidence 101 that a contract between you and me can affect other people.
And so what do you say to someone who says, well, look, okay, somebody goes to buy a house. They don't understand what they're doing. How can you say that's coercion? I mean, they wanted to buy a house. They didn't have to buy a house. They didn't have to get this loan. They didn't read the document, or they didn't, learn a basic tenet of that interest rates can go up or that property values can drop. I mean, why should, and this is really, I guess, to a large extent, the argument that supposedly launched the Tea Party. Why should we care?
Well, for one thing, as I said, the contracts that they entered with the banks didn't just affect them. It wasn't just them losing their house. They wrecked the world economy, you remember? Lots of jobs lost. They affected other people. Just the moment our daughter entered college, her college fund that we'd been saving for years and years and years went down by 30%. So we had a lot less money to use to pay for a college education, because the recession that was caused by all of this shenanigans, that affected me personally, even though I didn't have a subprime mortgage. I didn't have a mortgage of any kind at that point, right? The other thing is, the idea that somehow people are supposed to read 50-page mortgage documents and understand them. I'm a property law professor, and I can read those documents and understand them. But I think it's completely unreasonable to say that an ordinary person who doesn't have specialized knowledge can understand and absorb 50 pages of legalese. That doesn't make sense at all to me. I don't know how cars work, and when I buy a car, I'm really depending on Toyota or whoever I'm buying it from to make a car that's safe. I can do some investigation, consumer reports. I'm going to ask my friends about their experience, but I really am depending on them to make a car that's going to work, that's not going to kill me or my children, it's not going to be unsafe for other people. I depend on them to do a good job on that. And the same thing's true with those mortgages. I think people trusted the banks when they went in there and said, I want to get a mortgage that will let me get a house. And the bank said, yeah, this one's good for you. I think that at that point, it's not really the homeowner who's saying, look, I want to gamble. It's like I'm going to Las Vegas and I'm gambling. They weren't trying to gamble. They were trying to buy a house. There were some people that were buying houses to speculate, but the millions and millions of people, the unbelievable vast majority, were just trying to buy a house. And the bank really has to be careful, to make arrangements that are actually appropriate for people. And I think people have the right to trust people that they contract with in the marketplace. That's part of why I think libertarians should be on board with preventing deception. I think there was deception in the marketing of the mortgages, and I think the banks are the ones that have the ability and the obligation to stop, to not engage in deception when they're talking to potential buyers.
But now, continuing to sort of play devil's advocate here, if what they were doing was committing fraud, there's already fraud books, laws on the books. I mean, where does regulation come in here? In terms of bridging that divide to libertarians. I mean, I would add, just also using your car analogy. It is one thing to say that, Toyota has to be truthful when they say to me, this car is safe. But when we talk about regulation, we're not just talking about they need to be truthful. We're also saying that the government's going to require Toyota to put airbags in, let's say, or seatbelts, and they're going to require that of everyone. Why not just let Toyota make the case to me that this car is going to be safe even without airbags, let's say?
Well, because it's not. We know this, right? The cars are not safe without airbags, and the car companies wanted to sell cars without airbags, and a lot of people died because of it, right? So
but people
they can
die.
argue that it's safe, but
people die. 50,000 people die on the highways, every year with airbags. Why can't you let the consumer make that decision? I would prefer to pay less for this Toyota because it has no airbags.
Well, let's think about that. If you take the argument that we don't want any kind of regulation at all, think about building codes. Every single state has laws that regulate construction to make sure that houses are built in a safe manner. I kind of like those laws. My brother's house burned down because the prior owner did his own electrical work and didn't know what he was doing. And the fire started right outside the bedroom of my niece, and luckily they were not in the house. If they'd been in the house, she wouldn't be alive today. We have regulation of building construction. You have to be a licensed electrician to put the electricity into the house, and that is something that makes houses safe for all of us. It's true that it increases the cost of housing, and because people's incomes are too low today, that actually means that low-income people have a lot of trouble finding affordable housing. But I think the way we help poor people is not by making housing unsafe for the rest of us.